questions. So if you have any legal questions, give us a call at 407-536-6737. You can also text that number if you want, 407-536-6737, or you can email us at ask@dewitlaw.com. Sorry we haven't been doing this the last couple of weeks. We had some technical issues with our audio. I guess actually the last one we didn't have any audio on it, but we should have that fixed now. So if you have any questions, give us a call, shoot us an email. You can also leave it in the comments. I'll try to read and talk at the same time if I can, but I'll certainly respond back to you if I don't have that ability. So we got a few questions here this morning. Start us off from Bobby. Bobby wants to know, how do I trespass someone from my property? Can I trespass him because I don't like him, or do I have to have probable cause? So, short answer to that is you have to call the police to have them trespass. So if someone's on your property that you don't want there, you can call the police, have them issue a trespassing warning to them. And then if they come back after that, then they could be arrested for trespassing. As far as whether you can have them trespass because you don't like them or if you have to have probable cause, basically if you have right of possession of that property, you don't even have to own the property. If you have a lease on that property and that's your property and the other person has no legal right to be there, then you can have them trespass. So for instance, if you're a business owner and have a business and someone keeps coming on your property causing problems, you can call the police, have them issue a trespassing warning. If that person comes back, then they could be arrested for trespassing. They can't be arrested, and we used to get these cases all the time, back about 10 years ago. I don't know if they still do this or not, but they used to come out and just try to arrest people off the bat for trespassing. You can't do that. You have to issue a warning first, so there has to be some sort of warning before you actually have them issued for trespassing. So, good question there, Bobby. I hope that helps. And if you need anything else, give us a call, 407-536-6737. You can also text that number or send us an email at ask@dewitlaw.com. Let's take a look here. I think we have a couple more voicemails. Let's see if this one will play.
Hi. My husband wants to get a divorce, and he hired an attorney that wrote this agreement for me to sign. Do you think I should have an attorney review it? Because it doesn't give me alimony, and we were married for 17 years.
Try to cut that off before they leave their phone number there. So anytime you get an agreement, whether it's a divorce agreement or any legal document like that, and someone's asking you to sign it, it's always worthwhile giving an attorney a call and find out what your rights are. So in Florida, as you may know, if it's over a 17-year marriage, you're entitled to, there's a presumption for permanent alimony, meaning alimony for life or until that person retires. Again, there's more things that go into that. You know, alimony is based on need and ability to pay. What's one party's need? What's the other party's ability to pay? All that kind of fun stuff. So you have to look at the overall agreement. But, you know, I could probably spend an hour telling you stories of just horrible agreements I've seen people sign. I had one guy who came into the office who had signed an agreement where it was a 10-year marriage and he agreed to pay permanent alimony. Well, you know, in my opinion, no judge would ever have awarded his wife permanent alimony, but he signed it, he agreed to it, so he's stuck with it. I mean, there's not a whole lot that you can do at that point. So at least, you know, make the phone call. There's people who do free consultations out there. I think you get a more in-depth analysis if you pay a little money for a consultation. But sit down with an attorney, get some advice, get some feedback. Never sign a divorce agreement or anything else that people that someone throws in front of you. I find especially with family law, I think because, you know, there's emotions involved. Maybe people feel guilty, whatever it may be. You know, one party will say, "Hey, I'll just sign just give me whatever it is. I'll sign whatever." And then, you know, whether it's a week, a month, a year later, they realize, "Hey, I can't afford this agreement," and now they're in a really tough spot because there's not a whole lot you can do to get out of that agreement once you signed it. It's very, very difficult to get an agreement overturned once you sign on the dotted line. You know, with certain things like alimony and child support, if your circumstances change in the future, then you may be able to go back and modify that. But otherwise, you're stuck with the provisions of that agreement. So let's go to another voicemail here. Great question. See what these people have to say.
Hi, we closed on a home 2 months ago. Very nice neighborhood here in East Orlando, and the driveway, part of it is cracked. So we were getting some quotes on repairs and stuff because we really keep our homes meticulous. The cracking has been there for years. The prior owner did not want to fix it. He didn't give us any credit concession to fix it. So it is an eyesore. So we're basically settling in. And we get an email and a letter from the HOA giving us 30 days to take care of it, which I think is so unfair with COVID. We got an estoppel letter, and there was no violations or no issues on the estoppel letter. The neighbors have said that it's been like that for a very, very long time. So I don't know why the HOA is trying to bully us into 30 days. And that's my question. Obviously, we're going to get it done because we're those kind of people. But it's costly. Just to repair it is over a couple $1,000. The whole concrete, the whole driveway would be over $6,000, and pavers would be $7,000 to $8,000. So that was just my question.
Cut it off there again before the phone number. So a few issues there. I mean, you bought the house, there was cracks in the driveway. Typically, those are going to be visible to you, possibly. So it probably isn't a good non-disclosure lawsuit. So a non-disclosure lawsuit is when you buy a house and the prior owner deliberately hid some information from you, whether it's mold or cracks in the foundation or something like that. Basically something they knew about but failed to disclose. That's why it's called non-disclosure. Tough thing with those kind of lawsuits, though, is typically it has to be very high value to make it worth the time and money and effort spent. The other issue is whether the seller is collectible or if there's any kind of insurance to go after to try to, if you do get a judgment, to be able to collect on that judgment. Those are always the difficult provisions with those kind of cases. As far as the HOA goes, basically the HOA is sending you a notice letter, a compliance letter is what it sounds like, giving you 30 days to come into compliance. So you want to go ahead and write them a letter back right away and say, hey, we're making arrangements to come into compliance. Make sure that you don't have to get approval from them, from the Architectural Review Committee, because they could require prior approval. I've had people put roofs on houses before that were the wrong color, and then the HOA tried to have them take off the roof. Sorry for the phone. Phone keeps ringing like crazy over here. So you want to make sure that there's no requirement that you have the Architectural Review Committee approve it first. And if there is, go ahead and put the application in right away so that you can show that you're making all diligent efforts to comply. But you certainly want to take care of it right away. Typically they're giving you the 30 days notice because they're probably going to try to fine you after that if you don't come into compliance. So you want to make sure you take all reasonable steps to try to come into compliance as soon as possible so that you don't get hit with those fines, and then they can tack on attorney's fees, and they can file a lawsuit. It can be a big headache. HOAs can be a royal pain to deal with, frankly. So it sounds like you're already doing the right thing. Unfortunately, there's no real recourse for you against the prior seller. It is a big chunk of money, I know. It's probably not worth going after them for it, and I don't really even know that there would be a cause of action there. I think the bigger concern at this point is to make sure that you come into compliance as soon as possible to avoid any further fees or fines or attorney's fees or anything like that from the HOA. So great question. We always appreciate it. If you have any legal questions, give us a call, 407-536-6737. You can also text that number or shoot us an email, askask@twitlaw.com. We will try to do this every Monday morning. I've kind of toyed around with playing around with the time on it. Not sure that 8 a.m. is the best time, but we'll give it a try. I think we got one more voicemail here, so let's see if we can fire that up.
Hi, I have a question. The guy that hit me had his insurance company call me, and they made me an offer for my injuries. Do you think I should take it, or do I really need an attorney?
All right, so I cut this one off here, too, before they go into any great detail. Always a loaded question there. So, this is kind of one of the things that I preach about all the time because, in my opinion, the insurance companies will try to throw quick money at people to get them to take the offer, walk away from the case, and they basically get pennies on the dollar. Anytime I've ever posted a video or comment about this on Facebook, people always put in the comments, "Oh, well, the attorney's just going to take the rest of the money, yada yada yada." Look at it this way: the attorney takes a third typically in Florida, but the insurance company's own study said that the people who use an attorney get over 3 times what people who don't use an attorney receive for compensation. I think it's 3.5 times is what the study said. And that's a study that was done by the insurance company. So even if the attorney takes a third, you still get double the money on average based on this study. And again, every case is different. Every scenario is different. But from experience, I will say if the insurance company is offering you money up front quickly after an accident, it means that there is potential liability for them there, that they are concerned that they're going to have to pay out more money, because the reason they're doing that at that point typically is you don't know what your medical expenses are. You don't know what your future medical expenses are, and you may not have even received your medical bills at that point. So I had a good friend of mine who he accepted a settlement on a car accident case, and then he had to have a disc replacement a year later. Well, the amount that he accepted was nowhere near the amount to cover the disc replacement. Fortunately, he had health insurance and was able to still have the disc replacement done because it was absolutely necessary to do. But he accepted that offer too early, because you never want to accept an offer before you know what your total damages are. Basically, we always say people should wait till they reach maximum medical improvement in most scenarios, most cases, before they consider any sort of offer. Maximum medical improvement is basically as good as you're going to get. So that's as good as you're going to get. At that point, you should have some idea what the permanency is of your injuries, if it's going to affect you for the rest of your life, and if you're going to need future medical care. So, anytime the insurance company is offering you money like that, I would absolutely recommend hiring an attorney. I know people say, well, you're an attorney, you're always going to say that. But I really do think it's the right thing to do. I think people come out ahead, in the long run. It does take longer, to be frank with you. The insurance company wants to cut you a check and you'll get it right then and there. But I've had cases, I had a case settled last week actually where the insurance company's best and final offer was $2,500 and we got $9,500. I've had another one where the lady was dealing with the insurance company on her own for a year, and they said her best and final was $1,000. We got $14,000. And these are smaller cases, of course. But still, I think, the attorney knows, how to value the case, and the insurance company's hoping that you don't know how to value it. So that's my long answer to a short question. But if, like I said, if you have any legal questions, give us a call, leave us a voicemail, 407-536-6737. It's 407-536-6737. Text that number, shoot me a message on Facebook, email ask@dewitlaw.com. I'm happy to get back to you and answer your legal questions, and we'll keep trying to do this. So have a great week, everybody, and I will see you next Monday for another edition of Monday Morning with Mo. Take care.